Hey everyone, thank you very much for being here this evening. You're all very welcome to the Institute, and I hope you're all enjoying what might be spring now, perhaps, and that we will survive the blizzards of late this term. My name is Nora, and I'm the Director of the Information Law and Policy Centre, and this is our evening series for this term. So I see a lot of familiar faces here this evening, so I know a few of you already keep up to date with all of our events, but if you don't, please follow us on our mailing list or on Twitter. And now for this evening, it's my very great pleasure to introduce our panel. Our lead speaker, and do correct me on this, David, is the Honourable David Masuhara.
Well done.
It's not the Japanese version, though. We're going to try that later.
We'll practice later.
So, David is a judge of the Supreme Court of British Columbia, Canada. He is also an Inns of Court Fellow of the Institute for this year. For most of his career, Justice Masuhara has been involved in information technology matters, including various initiatives to move the court system in British Columbia to digital platforms and reviewing of their IT policies as well. And over this period, David has noted, and this is what's led him to the current research that he'll be presenting this evening in the working paper, that predictive algorithms rising from large data sets that have been developing in this area have been expanding more and more in the areas of law. And while he acknowledges that this poses opportunities for the justice system, he would also make the argument that these warrant serious exploration of their implications for the administration of justice, due process, and the rule of law. And joining us as our discussant for this evening is Damian Clifford. He is a visiting scholar at the Institute and at the Centre. He is joining us from the Centre for Information Technology Law and Intellectual Property Law from the University of Leuven, Belgium, where he is a doctoral researcher there, currently writing up. A very exciting period that we all know and love as PhD students. He has previously worked in the area of online advertising and enforcement, and has also been involved in several European Union Horizon 2020 projects researching law and technology. Damon also recently presented a very fascinating paper here as well a few weeks ago on emotion detection and the GDPR, which is available to watch on the Institute's website. So for this evening, David will present for about 30 minutes, give or take, David. And then Damian will discuss the presentation for possibly 10 minutes after that. We'll then open up the discussion to the floor for lots of points of information and questions that you have following up from David and Damian's discussion. And then afterwards we will have a wine reception, which I hope you can all join and stay as for. So I'd like to thank you all for being here this evening with us. And I'd like to invite David to speak on this evening's seminar topic, which is Artificial Intelligence and the Judiciary. Is there a role?
Thank you very much, Nora. I wish to thank you all for coming here this evening, and I particularly wish to thank the Institute for awarding me the fellowship to be here, and I also appreciate the very warm welcome that I've received. I can't say that as much about the weather here, but coming from Vancouver, I can tell you I feel right at home. It's not very often in most of our careers, and certainly me as a judge, that we have this kind of time to actually sit down and investigate and research an area. So I find this to be just a wonderful opportunity. My presentation is to provide you a little bit of background as to why I'm doing what I'm doing, and to discuss artificial intelligence and its intersection with the law, identify and discuss the pros and cons, which I think is the real key part for what I'm involved in right now, and identify some preliminary findings or some preliminary views that I've formed at this stage. Obviously, I have a lot more to do. And then suggesting some paths forward with respect to judicial decision making. And interspersed with some of this is in preparation for this and in preparation for a presentation I'm making to the Canadian courts, the Judges Conference in May in Newfoundland. I conducted a survey of Canadian judges, largely from British Columbia, but also from Quebec, Ontario, Saskatchewan, and Alberta. with respect to their particular views of artificial intelligence, their abilities with technologies, their understanding of AI, etc. So I'm going to provide you with a little bit of that interspersed with my presentation. With respect to my specific study here, it's not, as I mentioned, a personal interest, though it is a personal interest. It also has to do with my background and the role that I have, which is extrajudicial. I chair the technology committees for my court, the Supreme Court, as well as the Court of Appeal. I also sit on the court's technology board, which is the overall board for the province of British Columbia that shapes, conceptualizes, and plans, and then finally funds technology projects. Also, I've been chair, as well as with the National Federal Judges Communication Network and Safe Internet system, which allows for all judges to communicate in a safe fashion. So with respect to my role here, I'm here to investigate something that's very much on the forefront of the technology courts people in British Columbia and the judges as well, in terms of advancing access to justice and the administration of justice. One of the important contextual things that I want to raise to you is, what do I do in terms of a judge? The Supreme Court of British Columbia is a generalist judge court, and so we all have to do our own share of family, criminal, corporate, judicial review, constitutional work as well. So from the trial perspective, we get a very good view, a broad spectrum of cases that people are involved in the province. Let me just just so that you know, this is what Canada looks like, so I don't want to sell it too much. British Columbia, of course, is right here. My home court is here in Vancouver. That's the size of British Columbia relative to the United Kingdom. So we're about 4 times, maybe even 10 times the size in terms of population, but in terms of territory we have to cover. My court of 100 judges services this area. Just in terms of I sort of got a little homesick when it was really cold the last few days, so I took thought I brought some pictures here of the sunny days at the courthouse in Vancouver, and that's what it looks like on the inside. Now, in terms of the progression of things, of course, we've been moving from a paper, pen-based system, and while I've been here, I've had the opportunity to visit with the various courts here, the commercial court, the Crown Court, the Chancery Court, etc. And I've been able to see some of the digital platforms that have been in place there that are operating, and I was able to actually have the honor of sitting with His Honor Judge Edmonds in Ellswood Crown Court and watched how we use the digital platform they have there. And that is a circumstance that prevails throughout British Columbia too. We have a fairly robust e-filing system where documents, exhibits, scheduling matters are all dealt with. And that's what everyone talks about when you sort of move around, go to technology conferences. Basically, it's digital platforms. And so where we are today leads to the natural question of, well, if we've got all that digitization occurring now, why can't we move to artificial intelligence? Is there a system in place that allows us to move forward? Is there a system in place that allows us to have confidence in the judicial system applying artificial intelligence? And it is one of the areas that people asking the question, well, what does this all cost? And on an annual basis, the federal judiciary costs about $150 million per year, and that's basically for judges, the administration of the operations of the judges, not the facilities. In British Columbia, the cost is about $150 million per year, excluding the facilities. I just want to give you a sense of what the dollar picture looks like. In terms of moving then to artificial intelligence, what we have here, I just try to give you some definitions with respect to the computer system, which is able to perform tasks normally requiring human intelligence, such as visual perception, speech recognition, decision-making, and translation between languages. And there's a broad spectrum in terms of that definition, and no surprise, some people have a narrow definition and the general definition. And the general definition is what we see in science fiction movies, the all-thinking entity that does everything. We're not going to be talking very much about this today because that just goes so far. But we're going to talk about a narrower, or my context, when I talk about AI, is the narrower version where it's domain-specific, it's learning, it's applying different algorithms within a specific domain. Before we go too far, you'll have heard in terms of the general, the super intelligence. I thought I just put there. There's people talking about some pretty fantastic things. Any intellect that greatly exceeds the cognitive performance of humans and virtually all domains of interest. We've all read about that. What I wanted to point out here is, interestingly, Professor Benjamin Hilaire of the University of Toronto, who's not just an esteemed academic, but an individual who's actually created his own company that provides some software in the tax area, the employment area, and is doing some other research. He actually said this, and I thought this was quite interesting. Following on the astrophysical view of a singularity, and on top of the AI singularity, he has a legal singularity, which he refers to. It's just an interesting concept that I hadn't seen before. I have spoken with Professor Hilaire, and he has an article, a journal, that actually speaks quite in-depth about this topic. And it's just something to keep in mind as we move forward. What I'm talking about today is, or the context in which I'm speaking is artificial intelligence with respect to algorithms that are in place today. We all heard about those. There's rules-based, which are decision trees, different forms of decision trees. There's the machine learning, the autonomous learning. There's the deep learning through neural networks, which is a subset of machine learning. And then there's the natural language processing, which is in place as well to assist in understanding human language and embedding that with algorithms so that you can see whether answers can be given through the algorithms. Now, with respect to all that, where is that occurring today? You see a number of different organizations. Actually, every day you'll see another organization. I've just put this up. There's a number of organizations that are actually marketing these algorithms and these systems, which lends credence to the fact that they're actually building projects, building systems, and marketing systems to assist in the development of predictive legal analytics. In terms of the judges, we have the analytics that are supporting lawyers, and this is the most recent survey that I've done of our court. I've been doing it for close to 10 years, over 10 years. This is an interesting feature of the survey because virtually close to 100% of all the judges now are using computers regularly to do their jobs. And that figure used to be around 25% when I first joined the court, and that was 15 years ago. So there's this fairly significant uptake and people using the computers. I'm not sure why there's only 131 respondents in this, but maybe there are a few that need to embarrass talk about why they don't do it. In terms of British Columbia, I wanted to just go back for just a second about computers and a development that's occurred in British Columbia. We have an online dispute resolution tribunal. It's called the Civil Resolutions Tribunal, and it's chaired by a former clerk of our court. And that is a very important tribunal insofar as access to justice in terms of providing an online non-chronous platform for litigants to get their disputes resolved. It's in two areas: small claims and in condominium disputes. Do you have strata condominium? And the process they have is they provide guided pathways for potential litigants to have their complaints raised, their complaints mediated, and finally to have the matter determined by the tribunal. More recently in British Columbia, the new government has expanded that role to providing the CRT with responsibilities for motor vehicle accidents at a lower level. And so what's happening is there's an expansion of the online platform, and in my discussions with the chair, there is an openness to include the idea that potentially could be in our intelligent decision-making component if it works. So that's another reason why I find this an important point, because with respect to the technology board, there is a high desire in order to find these solutions and to embed them to achieve access to justice, to achieve greater efficiency and productivity. And with respect to the judiciary, I asked the question, there's 132 responses. Do you think at some point judicial decision-making by AI will occur at some level? I think this is pretty fascinating because it's a fairly conservative group of people that typically populate the courts. And close to 50% of the court are of the view that it will occur. And I thought that was quite significant. There's a continuous 30% or thereabouts throughout all the questions of sort of on the fence kind of question. People are not quite sure, and it's consistently 30%. But I think in the end, this number is going to get considerably higher, particularly if there's even a strongly agreed group, which I think is quite significant in terms of understanding the judiciary. I think this picture here, having spoken to many judges here while I've been here, this picture is pretty close to what I think would happen here in terms of a survey of the judges here. Now, in terms of judicial decision-making and AI, I thought I could just put this interesting quotation up here. I want to let you take a look at it. It's a fairly expansive definition, statement as to what judges do and what's involved in decision-making. This won't surprise any of you if you're involved in law, but this is the task that in some ways you measure what the judiciary will be doing when it embeds AI or potentially embeds AI into its processes. It's a daunting comparison if you were to think of taking some technology, putting it up against what the judiciary currently does today. So, in looking at this definition, I wanted to start with what some of the cons are, then to go over what some of the pros are, and then to give you a sense of what my views are at this point in time. I've been informed in my sort of research here by considerable work that's been done by academics in Europe, particularly with respect to the European Charter. And one of the key things, as in all circumstances, is the question of due process. Fairness, the ability to have notice, the ability to have an opportunity to contest an allegation. All of that is so key. And when you think of an AI system, we really moving too far away in terms of due process. Another one, and related, is the question of transparency and bias in coding. Again, with respect to the coding, again with respect to the programming, as we understand it today, as opposed to what it was in the past, there was an openness and transparency that the original programmers were talking about in order to avoid the very suspicions that has now arisen today. We have, as I mentioned, all those companies that are creating these business platforms to enhance their business and to earn profit. And of course, the investment that they placed in all these systems, they want a return on it. Therefore, the whole question is there's a lack of transparency. We don't know what's in the code. We don't have an ability to cross-examine the programmers. And that obviously weighs heavily on anybody thinking about AI in the judiciary. In terms of the development of some of the programs, particularly in the area of law, of course, there's a lack of legal knowledge of the programmers. Sometimes I'm talking to some of the programmers, they are very knowledgeable in terms of programming, coding, X's and Y's, and ones and zeros. But do we really have the knowledge in terms of what it is that's important when it comes to determining what the algorithms will be for a particular exercise in determining a set of issues? Again, in terms of transparency, there's the lack of knowledge as to how a programmer reached its conclusion. One of the big issues today, and certainly I've seen it with Professor Kerr of the University of Ottawa, who writes extensively in the area, is that with respect to the deeper or complex algorithms, which are the self-learning, self-teaching, the neural networks, the deeper the layer of the analysis the question goes to, the more difficult it is for anybody to understand how that logic, what is called logic, is operating. And in many circumstances now, there's just no ability for programmers and developers or anyone to really understand at what level the decisions are being made and what the logic has been. With respect to the vast storage of information that we have today, there's still questions with respect to what confidence do we have in the completeness of the data, particularly in a legal setting. There is a series of cases that people will recognize, but there may be more in terms of what is the data set that's being used. That is obviously an area where completeness raises some very large questions. On a structural perspective, there's the interference with judicial independence. Are we now ceding responsibility for certain decision-making, or all decision-making, depending on how far it goes, to some autonomous entity that's making decisions about people? Obviously, the further away you get from decision makers, the whole question of judicial independence is raised. I think the next two are pretty critical in terms of where we are today and in terms of the job, the task that's required of the judiciary. Presently, there's no system that can actually find facts. And that's really what we as trial judges do. We find facts. And then we take the law and we apply the law to the facts. There's no system right now, and I doubt if there will be, that can actually find facts. And the whole question then goes to assessing credibility. And so are we then left with systems as we understand them today in many different places, where we're left with information that we don't know and information that's being used in some fashion to find correlations and relationships, which is called profiling. And is that the kind of system that we want to be involved with in terms of finding decisions, not based on evidence as we put into the system by the parties, assessed by a judge, but rather simply some amorphous set of data which sets out to find what potential tendencies that there may be to determine whatever the issues are. Another one of the cons is that the system doesn't actually think. And that's a pretty important area. There's a lot of literature with respect to the system not actually thinking. There's the intelligence, the humanity, the direct connection between a person's intellect and the reasoning process versus a machine, which of course isn't thinking, but is trying to replicate something based on our outcomes. In terms of credibility, which is one of the last ones I wanted to put this definition up. I won't read it to you, but it's one which arises from Canada, which explains what is involved in assessing credibility. And if you read this definition of credibility, people will find it very difficult to think that a system is capable of assessing all these different factors. But this is what judges do every single day. And we're guided by principles such as this set out here. But there's so many different factors, so many different layers, that it'd be hard pressed to find that a system could do this. But in any event, there's a whole series, not whether technically a machine could do it, but philosophically, is it proper? Is it proper for some autonomous entity to be making these types of assessments about individual citizens, individual persons? The whole aspect of who we are as people and being judged by an algorithm, I find is very difficult to accept. And I think from societal perspectives, this type of definition just simply can't be met. And I have made some inquiries of some leading experts in the field, Professor Callow from the University of Washington, Professor Leuven at the University of Toronto, and while some work is being done to try to replicate this, they're nowhere near being able to do so. Continuing on with the cons, again, as I've mentioned, there's a lack of humanity and decision-making by AI entities. The next one would be the incompatibility with constitutional rights. That's a very large one. It is very large. In terms of, in Canada, we have the Canadian Charter of Rights and Freedoms. It is not as explicit as the European Charter and the directive that's just come down. It's in effect now, but in my view, the Charter, which protects rights and liberties, could easily be extended to cover off some of the issues with respect to being assessed through an autonomous entity. The next two are quite interesting in terms of the query that, in terms of law, in terms of the common law, how do you advance the law? If your database is basically static, and that is what's being assessed, then how is it that a data system can actually advance itself? And should it, or should it not advance the law in any of it? So that's another key question that I've seen as the con. With respect to statutes and regulations, again, natural language processing is at a certain stage, but there's no system right now that can properly interpret statutes and regulations. The language is too nuanced and contextual with respect to interpretation. You can see another con would be the intrusion into privacy rights with respect to the usage of AI in a fuller sense, if it's profiling, if it's accessing information that's not known to an individual who's being adjudicated upon. The next one would be the ex ante versus ex post reversal fear. I had some trouble trying to figure this out, but again, this is something that's written about by Professor Kerr from the University of Ottawa, who also, I believe, has been working with Professor Leuven on various issues in this area. And this has to do with as you get into more predictive and analytics, and that becomes the norm, the whole question becomes, are we now moving into an ex ante world where all of your actions are being judged before you do that, as opposed to today, where our actions are dealt with on an ex post basis? And that raises some interesting philosophical questions with respect to the trend today of how predictive analytics are moving ahead of us as humans in terms of the actions that we conduct. Moving then to the Canadian Charter of Rights and Freedoms, which I just mentioned, I wanted to just bring to your attention the specific language that we have. Life, liberty, and security of the person. Everyone has the right to life, liberty, and security of the person in accordance with the principles of fundamental justice. That's not as expressed and as explicit as the European Charter and the recent general directive.
General Data Protection Regulation.
But you can see the fundamental justice provision here is not just natural justice. It's broader than that term. And from my perspective, not that I would ever have to rule on this, but principles of fundamental justice would, in my view, easily be extended to include issues such as the protection that's embedded expressly in the European Charter. Another aspect, though, which operates against the imposition of an artificially intelligent system, is the Section 11 of the Canadian Charter of Rights and Freedoms. Any person charged with offense has the right, except for military law, to be tried with the benefit of a trial by jury. So, by definition, jury is defined as a collection of 12 individuals, and therefore, from a definitional point of view, there's very little room, particularly in the criminal area, for a serious crime, obviously for something that would lead to 5 years of imprisonment or more. So there's some barriers there in terms of how far we can go today with respect to artificial intelligence in terms of the judicial function. We see it in business everywhere. We see it with the law firms. They're doing everything they can. We see it with I've been told with respect to even my judgments that there's analysis being done for different things that I don't even know, which is determining various issues as to what my inclinations may be, what would be the things that come out from my judgments that indicate are significant or be of significance to the lawyer presenting the case before me. Interesting. I didn't put this out here, but interestingly, in the survey I did with judges, there's a good percentage of them that did not know. I myself would like to know them. A good percentage of the judges did not want to know what was being revealed by the predictive work that's out there. So, with respect, I'm going to, there's the general data protection regulations. There's the language there, and if you look at that language, you will see that it's fairly much more explicit in terms of the protection that's provided. And I'm not going to suggest that this would be imported into a definition of what the Charter of Rights and Freedoms would be. But what I would suggest is segments of this can easily be interpreted to come under fundamental justice under a Canadian Charter. Turning then to the pros, because there is obviously interest and there are various policy reasons why people would want to move down the road towards embedding artificial intelligence within the judicial decision-making process. Probably the most fundamental one that I've noticed, and certainly which comes clearly to me every day I'm in court, is there's a large layer of the public who do not have access to legal services because of the inability to afford the service. In my view, there has been the bar has vacated a significant area of the law that have never been there, or they've abandoned a large segment of our communities. And when I moved from the various areas on the map I was showing you, I go to the one communities, you will see just a number of people who really aren't able to understand what the issues are, understand what's required of them in presenting a case. At the same time, there are limited judicial resources that we have, and the priorities are set by the seriousness of the offenses and the seriousness of the dispute. So in terms of priorities, you can see that if you're involved in a very serious criminal case or you're involved in a very serious civil case, those will take priority. But again, what's happened to that vast layer of our communities who have everyday problems, significant to them, but they can't seem to be able to find a way into getting legal representation, legal advice. This third one is one that I hear very so often, that there's an expectation for the courts to address the problem and not just the government. Courts obviously being separate from the government of the day. There's a seeming request or demand, hope that the courts are able to do something. The courts, of course, don't raise money. The courts, of course, don't tax or funded by the government in the day. But yeah, there still is a requirement on the part of there's expectation on the part of the public for the courts to do something and address the problem. And so that then leads to the next point. I mean, what is available? We are aware, as I've already mentioned, that there are technologies that have been developed that utilize natural language processing and predictive methodologies, which can be used to find answers to legal problems. And as I mentioned to you, I showed you the finances, that there is a business case that can be developed to invest in to invest in the development of such a system. When you look at things like $550 million per year, and then look at British Columbia being about $150 million, you can take a small percentage of that and fund the development of some type of platform with a payback on a fairly reasonable basis. So that would be some of the pros. And one of the other things that comes into mind when we talk about prediction, we talk about algorithms. It's the language of, go way back to one of the great realists, great jurists. It was the language of Oliver Wendell Holmes. And you'll see this pop up in a lot of the articles talking about, well, we can do this. And there's a lot more depth to what Justice Holmes said. But when you look at some of these, people rely on some of these, and they say, well, we're talking about statistics, we're talking about prediction, we're not necessarily talking about logic. And so you'll see that this last one, for the rational study of the law, the black letter man may be the man of the present, the man of the future is the man of statistics, and the master of economics. And you can see some of that sort of coming into play when it comes to justification for doing some of the things that are occurring today in the world of technology. So then moving forward with respect to further pros, obviously if you had a robust working AI judicial decision-making system, it would allow for the optimization of judicial resources, which are scarce, and obviously you could save funding for it. Another one which is sort of personal to me, it's the cost of stressing the judicial resources can be reduced. Certainly our court takes a survey every couple of years with respect to the health and the psychological well-being of the court. I know that here there's been a study that was done recently by Professor Cheryl Thomas, and she recorded and surveyed all levels of the judiciary here, and it was quite interesting in terms of the level of stress that she was able to uncover in terms of her survey work. There are, and this is getting into a little more depth here, there are already rules and prescriptions used by the court which basically stipulate a result. There are rules that are already established in various areas of law for which a simple AI system arguably could be instructed to do. And just to give you some examples, I have a lot more, but child and spousal support, for example, that can largely be done today by calculations. There's tables that are used. There's always some judicial discretion which is permitted as exception, but for the majority of cases they're binding. So that's one area. Certainly with respect to, again, in the family context, cancellation of arrears, which is another one that comes up frequently in family court. There are very specific rules, very specific principles to be applied when it comes to forgiving or canceling arrears, very strict. And there are numerous factors, there's numerous rules of what actually, how narrow the ability it is to get your arrears canceled, and the numerous listings of excuses which don't work. Obviously, with respect to contract formation, when I'm talking about things like debts and things like that, I'm not talking about sophisticated corporate financing type documents, but everyday problems. Formation of contracts is really well understood, and all the different constituent parts that complies with the contract is in place or not. And one of the aspects I thought about in terms of contract formation, okay, so what happens if there's no contract, but something has been conveyed in terms of value and it's been received? Well, then you move into unjust enrichment. Unjust enrichment, of course, has a number of very well understood principles. You have to have a deprivation, you have to have an enrichment, and there has to be no juridical reason for the enrichment. Yes, that sounds kind of legalese, but that can be broken down into rules. And my belief is that there are other areas Damages for claims in tort, again, that's sort of an assessment. So again, would you say, well, how does that fit into rules? But if we're talking about certain types of injuries, there are abilities to get the recent cases and the levels of damage and to compare them with the level of the injury. If that, of course, is all of that needs to be done. If there are no issues with respect to facts, that can easily be done with respect to the level of the damages. You ask me though, but isn't it supposed to be a unique and individualized process? My answer is yes, it is. Every case is different. But in terms of getting to quick answers, in terms of doing it cost effectively for people who don't want to wait, because delay in the system is quite a problem, this type of process will be quite amenable. The last two are quite interesting. If you've been reading anything to do with Professors Kahneman and Tversky with respect to how do we actually know how decisions are made? There are many externalities, there are many influences that arise in terms of judge making. I don't know if I put one of the slides. I thought I was going to put a slide up. I'm not sure if it's here. Let me just check. About half the court, when I asked the question, given all the different theories and approaches to how judgments are made, do you really know how a judgment has been reached? And a good percentage said no. It's quite telling, I thought. And it's quite consistent with the work that's been done by the psychologists in terms of looking at what are all the different issues that go into making decisions and how those decisions can be wrong. And so we have optimism bias, confirmation bias, illusion, et cetera, that's going to be covered off. A simple book to read, if you're interested, would be just Moneyball by Michael Lewis, who talks about a lot of this work in the context of a baseball team. And so, not that I would say that you'd ever say that judges don't know what they're doing, because in terms of the legal work, there's obviously a strict construct, known principles to apply, but at the same time, there's a high level of variability, high level of discretion, which involves itself with respect to reaching decisions in any particular dispute. So, in terms of the pros and cons, there's a number of things to be balanced here. But in terms of my own view as to where we can go, right now, there is no technology capable of resolving factual issues, including assessing credibility. There are some serious ethical and constitutional barriers to making decisions by AI, particularly in criminal matters. There are cases which can be managed through a program inquiry where relevant and material facts can be elicited and where they are not in dispute. Such cases can be decided by properly constructed program, and sufficient parameters can be prescribed to preserve the jurisdiction of the court as governor of its own process and meet the conditions for transparency. So having all that in mind, and actually I wanted to cover something that I mentioned earlier. With all the concerns, the cons, they're very serious, and they have very, very serious implications for the court, the judiciary, in terms of its independence, its role, the fairness that it's required to provide, its level of confidence that it's supposed to imbue in society with respect to the judicial process. Those are all very important, and the cons really weigh in favor of saying, in terms of being cautious in terms of not doing anything that would cause consequences that are unanticipated, one would say one should not engage in this type of activity. On the other hand, what we find ourselves confronted by is a series of very serious social deficiencies today. We have communities, we have layers of people who aren't able to get legal representation. Bar, in many ways, vacated the area. Having been a governor of the Law Foundation of British Columbia for 6 years, where we were injecting $30 to $50 million a year to community advocacy groups throughout the province, the demand simply can't be met, and at the same time, their ability to represent people within the court system is limited in any event. So we have that circumstance where we have a number of pressures, real pressures both in law and in terms of technical feasibility, of simply saying we should be doing this. And at the same time, the pressure is there that something needs to be done. And individuals in society need to have some opportunity to have their cases heard. So having that in mind, I'm proposing at this early stage, and again, your commentary and everybody else's commentary is welcome. What I'm suggesting is identifying a discrete area of law where there's significant community need, and for which there is little legal assistance. I should also say little opportunity to get to courts, because many courts are quite a distance from a lot of the communities. Developed through rules-based natural language processing decision methods in the specific area of law, using programming experts working alongside legal experts, including judges of the court, and rules-based because this would permit transparency. You would be able to see what the construct is like, as opposed to the deeper neural networking type processes. The system would be developed and operated under the authority of the court to preserve the court's jurisdiction, preserve the sense of independence, and provide continued confidence with respect to the system if it should be developed. And the system would operate with evidence imputed to it. That is, say, would not be deciding on personal data or profile data. What I mean by that is it would still be the individual litigants imputing the information, the evidence that they want to rely upon into the system, and that the system itself does not reach out and then pull back information which one would call profiling data. Cases where credibility assessments on a material fact, where a material fact is required, would not qualify. And that really goes to what I had mentioned earlier, that in terms of assessing credibility, in terms of determining disputed facts, that issue is too important for that to be determined by an autonomous entity. That is not to say, however, that facts cannot be found. And what I mean by that is facts which are relevant, facts which are material to an issue, can be discerned in the absence of any conflicting evidence. And what I mean by that is, if one party simply says, here are all the facts that they're relying upon, they may have no relevance, they may not be material to the issue at hand. The other party may simply indicate what all the facts are. They may be totally relevant, they may be totally material. And in that equation, you would find that the system could say, the relevant facts are available, there's no contradicting relevant facts, and therefore, by elimination, the rules-based process would provide you with the result. Now, this is another important aspect of ensuring a level of due process. The system would be designed to provide the basis for the decision reached, so you would get an answer that would be sufficient for a proper appeal or judicial review. One of the key things for any judicial decision maker is to provide a proper explanation, to provide proper reasons for how the decision was reached. This would be something that would be pretty important. It would be one of the challenges for the system, but it would have to be a necessary condition for any type of judicial AI system. The information would have to be outputted with a sufficient level of reasons, intelligible reasons, so the reviewing court would be able to tell what it was that led to a particular result. The judicial review of appeal would also be properly populated by human judges. That would be an important feature here as well, so that the chain of command, the chain of seniority would involve human input. And at all times, this is my own particular view, is that all times the parties should be aware that the system that they are addressing is inanimate and not one that pretends to be a human one. And that is to just keep front and center to everyone. They are not dealing with a human entity, but they're dealing with inanimate. And in terms of moving forward, public consultation obviously is the key to all of this. And that is one of the recommendations that I'll be making to our board in British Columbia with respect to public consultation. There may well be reaction which simply doesn't accept any of this. There may be arguments that say all that has happened here is that the people who can't afford services, the people that can't access the courts, are simply left behind again and given a less than full solution. But as I say, the problem we have today is that there exists a problem, and something has to be done. The difficulty is that the funding is simply not there, the capacity of the courts is not there, the legal profession, for whatever reason, is not able to service that particular layer. There's a great demand. We recently had a public commission that investigated the whole area of this, legal services to the public, and the report was quite dismal in terms of what was available for people and the need. All of it was premised upon the need for greater legal aid, but of course from a governmental perspective, it just isn't. And so I think it's a prolonged problem. So from my perspective, this is the potential model that I'm suggesting, that I'm testing things off against. And there are many policy reasons for why one would not go down this way. Lots of literature regards which I've reviewed in terms of going way back to computer developers from the 80s. Stephen Weisbaum, who talked about the loss of our humanity in terms of moving on and relying upon computers. More recently, Damian brought to my attention Professor Lessig's writings, where if you start to go down the road of embedding algorithms, it's the code that becomes the law, and there's a real threat that is. My response to some of this is that the court itself governs the process, and the court itself is the one that can have oversight over this. This is not an open-ended private organization that's coming in for profit to sell a system. My solution, my recommendation here is to utilize the resources that are available, fund it publicly, develop it publicly, and to have it transparent and have it continuously reviewed to ensure biases and prejudices are screened out. So at this stage, that more or less concludes my view here with respect to the pros, the cons, and the working model that I'm suggesting.
I was asserting that I was doing the judges, so.
David, thank you very much for a very wide-ranging overview of not just how AI will affect the judiciary, but also how it will affect the criminal justice and public administration of justice more generally. I thought it was really interesting as well in terms of how you talked about the current challenges facing justice systems, and I don't think they're in any way unique to British Columbia in terms of the lack of resources, in terms of the constitutional challenges that would be raised if we did start relying on purely AI decision-making systems. But before I say anything else, I'm going to pass over to Damian for his comments, and then we can open it up to a more wider discussion.
Thanks, Nora. So I'm very happy to be here and commenting. Thanks for the presentation. I suppose when I got the invite, I was a little bit, it's kind of a question, but like, what is AI and what is AI in the judiciary? Now, I think you've narrowed it somewhat from kind of a very broad start, but when I was started to think about this in a European context, I suppose most of my work is really based on commercial applications of AI systems, and in the discussions that I suppose that the work that I've been doing, a lot of it has been focused on fairness recently over the last year and a half, and it started to make me think about a little bit of the EU literature and the focus on accountability and transparency, and the inherent problems that AI presents in those contexts. And in this respect, we can also point towards the discussion in relation to the automated individual decision making and the Article 22 that David brought up from the General Data Protection Regulation, and the interpretation discussion that has been ongoing from that, both in academia but also from the Article 29 Working Party. And I think in a commercial sense, a lot of this is linked to, the trade-off between trade secret protection and privacy rights and data protection. So the commercial entities don't really want to tell you how their profiles are developed, etc. And they have an effect on the privacy and data protection rights of individual citizens. And inherent in all these there's the risk of discrimination, but also differentiation. So discrimination is on very set grounds, but also there is the ability to differentiate different citizens on the basis of characteristics that aren't protected by law. So a lot in a commercial context, a lot of this is that's the type of discussion we're having, and a lot of it has to do with the lack of transparency and the lack of ability to audit how companies are actually using profiles. But I suppose when I started initially thinking about this as well in this particular context, I was also just wondering about transparency as well here. I mean, and I think you touched upon this towards the end, David, but I suppose it's also a question of how transparency will actually work for AI and the judiciary. So, I mean, is it something to do with public procurement phases that essentially IP rights would be essentially assigned away, that there will be no trade secrets, that everything will be open to the public, that academics can essentially assess these mechanisms, are encouraged to do so, and to weed out any potential problems. I think that's what you've been suggesting. And I suppose then it links back to my initial thought when I was invited to do this, is the extent of the application of AI. So in the Article 22 of the GDPR, it speaks about solely automated individual decisions. But I suppose I'm a little bit hesitant in terms of what is meant by the applications here. You advocated a narrow approach, and I think in your proposal there as well, it's also visibly narrow. In a European context, it kind of triggered in my mind the discussions around the online dispute resolution regulation, which essentially deals with small claims again and cross-border business-to-consumer complaints. And it links up with alternative dispute resolution. So I suppose one of my questions related to, is actually that the best place for some of this? Would it be within alternative dispute resolution with judiciary, the judiciary essentially as the backstop? If this doesn't work, the complainants can go then. So that would be, I suppose, one of my first questions. I have a lot, I suppose, but they go down a little bit more of the dystopian view of this, the broader view, which I think, we discussed this as well as the slippery slope, so once you start, where do you stop? And it just raises questions about, what is assisted decision making versus, what is essentially an algorithm making a decision on the behalf of the judge and then some just rubber stamping it. So I think that there are certainly questions there in terms of agency. And so I suppose a lot of it deals with, a lot of my concerns are really circling around the fact that transparency mightn't be the solution to all of AI's problems, essentially. Now, I know that you're advocating more of a decision tree approach so you can see the logics, but I think it's a short step then as well. So it is, it's something that I suppose is raised in my mind when I look at it. And I suppose you spoke about, biases and the research on cognitive biases and bounded rationality. And I was just wondering that if we start down this path, are we just substituting irrationalities that we can measure for irrationalities in a computing system that might be very difficult to detect in more of a longer view? So I think that there are certainly two questions. I'm just gathering my thoughts now because I wrote down a few more, but I'll just see how many I'll give you. I suppose that the other, you mentioned as well the role of the jury, and I found that, I suppose again it links to the where these systems will be deployed, and what context. If it's small disputes, similar to an online dispute resolution mechanism and the ADR platforms or something like that, then you can see that there mightn't be as major procedural issues, procedural law issues with that. But I suppose when you get into the criminal law aspects, it kind of goes insane, as you mentioned, in terms of ethical consequences potentially. And I was just wondering, is it really, a jury of your peers plus the AI, plus an AI algorithm is what you would be looking at in the future, and the potential consequences of that deployment. So I think, now you did mention that, but I was interested in whether you have thoughts to further expand that. I think the last point I suppose I'd like to make is just in terms of what if something goes wrong, because I think it's an interesting question to ask in terms of the risk analysis of the deployment of something like this. I mean, who would be liable for something if something went wrong? Who's accountable for this? Now I think that also links back to the biases. We all know that there are problems with human decision making, and we potentially might be holding AI to a higher standard. But is that natural? Should we be doing that? I think that there are several questions around that, and I was wondering what your thoughts are on those questions as well. So I think I'll leave it at that. I think I've hit some very difficult questions.
Good insights there. In terms of the location of the ADR or online process, part of my thinking here is that it should be within the court system. There are ADI processes for online disputes. I mentioned the civil resolution tribunal, but it's an agency. It's an agency of government. And while I think in terms of the principles here, the court itself is its own separate arm of government. It's not a part of government. It's a third arm of government overall. And it has its own specific jurisdiction. It has its own independence. And in many areas, not to say many areas, but some critical areas are still within the jurisdiction of the court and not within the jurisdiction of the tribunal. And family area, for example, the parents' patriarch jurisdiction of the courts, you couldn't download that to another agency. So that's just an example of, from my perspective, there are some critical issues that need to be dealt with within the context of the courts. At the same time, I'm open to the idea that some of this could be embedded within a different tribunal. Certainly, but what I was trying to address were issues such as accountability, independence, etc. And so that's my answer to the location. Typically, there are matters which are within the jurisdiction of the court that typically should not be delegated to another authority. With respect to the question of rationality, that's a very interesting one. But the data, if you want to talk about in terms of rationality, where the decision making is being done is within the large repository of decided cases. And so to the extent that there's questions with respect to rationality, there's questions with respect to bias, arguably you would say it's already there. And it's not the right answer in terms of the bias being present there, but it does exist. And that's one of the reasons why I think the rulemaking is really important, because I have a concern that if you go too deeply into the analysis of the cases, there may well be certain biases, certain relationships which we're not even aware of, which then become, which surface in the decisions made by an AI decision maker, which you would not be able to discern because of the complexity and the layers in which the algorithm is operating. So that's but just getting back to the rationality part, I think if you look at some of the various cognitive biases, etc., I have this ongoing discussion with a friend regarding do we really know what caused us to do things? Because as judges, of course, have you all heard about the little study that Kahneman and Tversky did? And I can't remember which book it is, but they observed in Israel the criminal court there. Well, what they did was they studied this, and I see there's somebody here has, they studied the decisions by the criminal court judges, I think it was to do with bail or parole, and they correlate the decision based on whether they're getting close to lunch or the afternoon break. Now, there may be no reasons why they decided that, but it's an interesting discussion as to how the judges make their decisions anyways. But I think the comfort that we should be taking is that there are strict constructs that judges have to deal with, and particularly with respect to more complex ones. You know, the one-offs of, yes, you get to spend the weekend at home, or yes, you're not able to, you're going to have to spend the weekend in jail with respect to parole or bail. But more complex decision-making, ones that require a bit more deliberation, those are within strict confines. And two, that's why I think the really important feature here remains that any decision would obviously have to be open to judicial review or appeal by a human tribunal. Now, what if something goes wrong? What's the accountability there? Well, the accountability would be the court's responsibility, obviously. And good or bad, judges, we make decisions. Sometimes we're reversed. I get reversed every so often. Somebody says, "Well, you missed this point," or whatever. And that's, if I were to commit a crime, obviously my accountability would be is that I would be relieved of my duties and sent to jail or something like that. But in terms of judicial accountability would be the censure that would come from misconduct. But in terms of making a wrong decision, or being reversed, that's not necessarily anything bad. It's just me being or somebody's opinion that perhaps I missed a point or I misinterpreted a particular point. In terms of a disaster scenario where the system fails terribly, well, it may well be that people have to be. I do lots of class actions, so I'm not thinking all of a sudden that I'm not sure whether you can sue the court, but you can sue. There must be somebody that you can see some remedy. I'm not sure who. But there may be a remedy. In terms of the role of the jury, my answer to that is I don't think that there ever would be a computer that would take the role of a jury. It doesn't fit within the construct of our Constitution. Thank you. Any other questions?
I'll let Damian just follow up on one of the points you made, but I'm going to take advantage of my position as chair and just say that I think all the analogies you've drawn to the jury to be really interesting in that, they are there to deliver an assessment based on everything that's been presented to them in court. They're not legal professionals. They're the face of human compassion, for example, the representatives of the community. But what's interesting is that in certain jurisdictions, the jury has been very much sidelined. So if you think of the US, you have the plea bargaining system. Think of the UK, you don't have 12 jurors anymore. You can have it whittled down to 9 in certain circumstances. And I do wonder, how much of a role in certain jurisdictions the factor that you mentioned about the pressure of resources, the emphasis on accuracy, the emphasis on utility is going to play in, say, civil law proceedings as opposed to criminal justice proceedings. Because, certainly from a EU perspective, with general data protection regulations, there's been a lot of emphasis on what David mentioned earlier on Article 22, and the fact that you have a right not to be profiled if the automatic processing is solely undertaken by that system. And then a lot of critics have pointed out that, well, that can be easily sidestepped because as long as you don't rely on that system completely, as long as it's just a support or it's just augmenting the system. So a judge, for example, saying, Siri, what should I do in this situation? Surely we're not getting into any trouble there. But certainly in terms of how AI could be implemented in courts in the future, for the lower courts, for quite straightforward cases, civil cases, we were just talking about identifying patterns. You're not talking about questions about justice, family law, criminal justice, high-level constitutional issues. It seems increasingly likely that there would be a push for there to be an automated judge and then have the right to review that you mentioned earlier on to a higher court. But I'm just going to leave your comments there, let Damian follow up, and then we can open it up to a wider discussion.
Yeah, well, I just have one point. I suppose just in relation to the, what if something goes wrong point. I suppose my point is if the system is extremely nuanced, the flaw could be inherent in thousands of decisions. So, okay, if you're a judge and make a wrong decision in one case, you're overturned. When there's a flawed algorithm, it makes the same decision in thousands. Is the whole system then in disrepute very quickly and very easily? So I think, there's a danger that the entire thing could be like a house of cards in a way.
I think you're right. The reputational aspect is so key. Failure of a system like that would damage tremendously. Depending on the extent of the failure, would damage the credibility. And that's why there would have to be considerable care, considerable testing, ongoing review of the system. But you can't avoid the fact that if there was a major failure in your scenario, thousands of people were unjustly treated, that could be a very serious blow. So the reputational aspects are really very key in terms of the most person in any leadership position. From my perspective, there's a good argument to simply say yes, there could be problems, but depending on the layer of, depending on the types of disputes, there may not be as material an impact in terms of the relative statement. Material impact on the individual who's wrong, of course, would be in some cases very, very hurtful and damaging.
Okay, I'd like to open it up to the floor now. If anyone with questions, just raise your hand, and if you don't mind briefly introducing yourself before your question.